Good morning, everybody. Thank you for your patience. We have a very, very, very packed committee hearing today, and I have spoken with many of you this morning and yesterday. And so for those of you who have expressed a desire to speak this meeting, please know that today what we are doing is we are taking testimony only on Senate Bill 410, and we are taking testimony only on House Bills 4207 to 4215. And we will be voting out House Bills, the very riveting, exciting bills on probate from 4863 and 4864. Due to the number of people wishing to speak, I know some of you have already approached me. If we cannot accommodate you today, there will be an opportunity to testify next week. So I'm going to beg the patience of the committee and to the committee members. Also, I will apologize for this larger package of bills. It has been a long time coming. We have been waiting. Everybody's been working hard, and I know there are a lot of questions, and that's why I'm happy to say you will now have a full week to review these bills and ask additional questions next week. So, first things first, Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Hope. Here. Arbit.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 13 members present. You do have a quorum.
Thank you. I will take a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. Thank you for that motion. Those are now adopted. We have no absent members. And the first thing I would like to do is take up House Bill 4863. And I will take a motion from Representative Carter to report House Bill 4863 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Yes.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4863 is reported with recommendation.
Thank you. I will now take a motion from Representative Hope to report House Bill 4864 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Yes.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 13 yeas, 0 nays, and 0 pass. House Bill 4864 is reported with recommendation.
Thank you. We are now going to turn to Senate Bill 410 from Senator Irwin. Is Senator Irwin here yet? No? Okay. In that case, we're going to have to turn to House Bills 4207. 5207 to 5215. I'm going to be calling witnesses up in groups, and please note that if you do wish to speak or if you do have remarks you'd like recorded in the minutes, I need you to submit a card. So I'm going to call up Representative Steckloff, who is apparently going to join us in the minute. Okay. While we wait for this, I'm going to read in some cards. We have Cynthia Misfud on House Bills 4863, 4864, and House Bill 510. Wishing to speak, but unfortunately, due to the time constraints, she is neutral on those bills. On, just read this, House Bills 4863, 4864, Ashley Steffen from the Michigan Department of Attorney General, supporting the bill, not wishing to speak. And on House Bills 4863, 4864, and 5210, not wishing to speak, neutral on the bills, Julie Bratton. So we are at a little bit of an impasse here. The committee's going to go at ease for a moment. Representative Steckloff, we would love to have you join us at the table. We are now back on the record. Do you have any witnesses you would like to call up with you?
Yes, I have a few with me today. All of their testimony has been provided. My team would like to come on up. Okay.
Okay. Joining you is a fellow Judiciary member, Jason Hoskins. And I'd like the witnesses to introduce themselves, please. Okay, make sure your red buttons are pushed when you introduce yourselves and talk. Thank you.
Jane Bassett, attorney from Ann Arbor.
Thank you.
Stephanie Jones, Michigan Fertility Alliance.
Okay.
And then we also have someone who is on Zoom, who's coming in virtually.
Okay. Polly, I believe?
Yes, Polly
Okay,
is
thank
here.
you. Proceed.
Thank you, everyone. Thank you, Madam Chair, members of the committee. Thank you so much for allowing us to come in today to testify on this important bill. Today I come before you as the proud primary sponsor of the 2023 Michigan Family Protection Act, which is House Bills 5207 through 5215. These bills, which I will briefly overview in just a bit, represent the most profound, up-to-date Michigan's parentage laws in 30 years. Michigan's families have changed a lot in the last 30 years, and our law should reflect that. There are so many reasons why a family might have an untraditional route to parentage, such as health-related issues that make becoming pregnant impossible or dangerous. As many as you know, I am one of these people. I am unable to naturally conceive due to chemotherapy treatments as I battled breast cancer. My husband and I, and many Michigan families like ours, would like to start and grow a family. But in order to do that, legally in this state, many of our parentage laws need to be updated. This package is about parentage and protecting our families. Protecting and dignifying all of Michigan's children, no matter how they were brought into this world. Members of the Judiciary Committee, with respect for your time, I'm here on behalf of so many of other sponsors, and our bills include the following. House Bill 5207, which is mine. It assists Reproduction and Surrogacy Parentage Act, updates Michigan law to ensure that children born through assisted reproduction and assisted reproduction with surrogacy have a way to establish legal parentage. This also provides clear standards and protections for all parties in a surrogacy arrangement, children, parents, and people acting as surrogates. It also ensures greater efficiency and consistently in our courts to access to justice. 5208, which is Representative Morse, it amends the Public Health Code, updates the Public Health Code to ensure that children born through assisted reproduction and surrogacy are able to obtain birth certificates like all other children. 5209, Representative Breen, this repeals the Surrogate Parentage Act of 1988 and repeals the criminalization, I'm going to say that again, criminalization of surrogacy agreements, as Michigan is the only state in the U.S. that retains criminalization of surrogacy. 5210, Representative Hoskins amends the state and protects individual code, updates this code with inheritance to ensure children born through assisted reproduction or surrogacy have access to the same interstate succession rights as all other children in Michigan. 4211, Rep. Conlin amends the Parentage Act, updates this act to clarify that parent agreements from other states are recognized in Michigan and that parentage of children born through assisted reproduction and surrogacy is established under the Assisted Reproductive Surrogacy Parentage Act. 5210, brought to you by Representative Morgan, amends the Revocation of Parentage Act, amends the Revocation of Parentage Act to ensure it's inclusive in children born through assisted reproduction and Surrogacy Parentage Act. Rep. Cerniglu, amending the Summary Support and Parentage Act, updates the Summary Support and Parentage Act to clarify the parentage of children born through assisted reproduction and surrogacy is through an Assisted Reproduction and Surrogacy Parentage Act. Representative Pahusky has 5214, amending the Knowledge of Parentage Act. It updates the law so that the intended parents of children born through assisted reproduction can secure their parentage through acknowledgement of parentage. This inclusion allows more children to be secured by a simple form at the time of birth. And then Representative O'Neill amending the Genetic Parentage Act, updates Genetic Parentage Act to clarify that children born through assisted reproduction and surrogacy is through the Assisted Reproduction and Surrogacy Parentage Act. And thank you so much for your time, and I'm going to turn it over to my colleague, Representative Jason Hoskins.
Thank you, Representative, and thank you, Chair Breen, and members of the committee for taking up this important legislation. And I want to really thank Representative Steckloff for her leadership on this very important issue, an issue that has affected so many people, so many families here in our state for far too long. Today, we get to expand the options for creating a family here in Michigan and extending the profound experience of parenthood to so many people. Now, there are certainly options for creating a family. Adoption is a route for many people to become parents, but surrogacy is another important tool for potential parents that needs to be made available here in Michigan. In fact, for so many, surrogacy isn't just an option, it is the option. It is a lifeline to family that many have always dreamed of. It's a chance to hear the laughter of a child, to hold your own flesh and blood, to experience the indescribable joy that comes with parenthood. Today, we are creating the legal framework necessary to protect the safety and well-being of everyone involved in surrogacy. With this legislation, surrogacy agencies, clinics, medical professionals can ensure the process is carried out responsibly with the best interests of both the intended parents and the surrogates at heart. This legislation establishes the legal guidelines for contracting, reducing potential risks and disputes. Certainly in a political landscape that can be filled with bitter disagreements and partisan politicking, we have the option here to really grant this kindness of family to our constituents. This kindness to allow them to have a family the way that they like, on their terms, on their own terms, using surrogacy. There are families out there that might be incomplete or unsure about what the future holds, and today we can take the steps to grant them that future, the dream of holding their newborn child and completing their family. I want to thank you again, Chair Breen, for taking up this legislation, and I am going to turn it over now to Stephanie Jones.
Thank you again. My name is Stephanie Jones. I'm the founder of the Michigan Fertility Alliance. Thank you for being here today as we discuss a critical issue that many of us in this room know personally and that affects countless families in our beloved state of Michigan. We are here to address the urgent need to update our parentage laws to ensure the protection of all children born through fertility treatments and surrogacy. This bill is in step with what the Supreme Court requested this summer, to provide clarity and protection for all children born through assisted reproduction. You'll hear from a tapestry of experts and Michiganders who know all too well what it feels like to face unnecessary suffering, all because Michigan law is out of step with the modern family structure and advances in fertility treatments, ultimately leaving our children in legal limbo and robbing some families that chance to have children. You may be asking how Michigan wound up in this predicament. There is no short answer and not enough time. An antiquated 1988 criminal ban on surrogacy contracts, as Rep. Steckloff mentioned, and a general lack of understanding on how families are formed today are the main culprits. With that, please welcome legal expert Polly Crozier.
Thanks so much for having me, Chair. And members of the committee, and thank you to Representative Steckloff and all the co-sponsors for their leadership. My name is Polly Crozier. I'm the Director of Family Advocacy at GLAD, where my work centers on protecting children and families, particularly updating parentage laws. Parentage is the legal status of a parent-child relationship, which gives rights to rights like custody and decision-making, and responsibilities like child support and health insurance. Parentage is so important to a child's well-being and ability to thrive throughout their lifetime. Children thrive when their relationships with their parents are secure. Unfortunately, many children in Michigan are currently deprived of that security because the law doesn't treat their parents as legal parents. By treating some children as lesser and unequal, namely children born through assisted reproduction, children born through surrogacy, children born to unmarried parents, and children born to LGBTQ parents, Michigan leaves children vulnerable and undermines their well-being. The Michigan Family Protection Act solves those problems. It satisfies constitutional requirements. It reflects the diversity of all families in Michigan. It protects children who are vulnerable under the current law. It brings order to an area of the law where there's now chaos and uncertainty. It promotes efficiency in the courts, and it updates outdated law with best practice. What the bill does briefly is it provides a clear path to parentage for children born through assisted reproduction, provides a clear path to parentage for children born through surrogacy, and protects all in that process. It ensures children born through assisted reproduction and surrogacy are included in our other core laws, like birth certificates, intestacy, and paths to securing parentage. It essentially assures more children in Michigan are protected from the moment of their birth. My experience in collaborating on this package has been really positive, and I can speak to the package as a well-vetted and best practice approach to protecting children and families in this state. A coalition of families and organizations, some of whom you'll hear from this morning, support this important effort. Those are wide-ranging organizations from law reform, children's rights, justice and equity, fertility healthcare, among other areas. I just want to thank you so much for your time engaging with this important package. I'm happy to answer any questions now or in the future.
We have questions from two of our representatives. I would ask that they keep them brief and also remind them there will be lots of opportunities to speak next week as well. Representative Outman.
Thank you, Madam Chair, and thank you, representatives, for being here and for your witnesses as well. I'm a little bit familiar with this issue, but it's been a minute since I reviewed it. Could you clarify just a couple of things for me? Number one, you can go the surrogacy route in Michigan, but you just can't contract. Is that one of the main issues at hand here?
I think I can probably answer that. Contracts for surrogacy in Michigan are unenforceable, and in some cases, there are criminal penalties for entering into those, including paying a surrogate or paying for reimbursement of expenses for a surrogate.
Okay. It seems like there was a kind of a high-level incident, maybe involving a Grand Rapids couple recently. I lack the details of that, but I was just kind of wanted to elaborate, what the contract issue of at hand here and surrogacy in Michigan. And my second question, and something that kind of prompted through you guys' testimony, could you just elaborate on how children of surrogacy don't have the same rights as other children here in Michigan?
Yeah, I'm going to just butt in real quick. Actually, that family will be here next week.
Oh.
So with all the questions you have, and that is a true story of what's happening for multiple families in Michigan. For example, that family, you typically, without having the contract or the legal birth certificate, have to go through an adoption agency to adopt your surrogate child. And you'll hear from a lot of children and parents that have had to go through that route. And that's a huge issue. What if your child is born through a surrogate and has to go in the NICU? There is absolutely no laws in Michigan that protect that child. Whose health insurance are they under, and who are the intended parents? So these are all those little things that we need to fix.
I see. I can see how that could be problematic. Thank you for clarifying something.
Thank you, Representative.
Representative Fink.
Thank you, Madam Chair, and I appreciate that we're going to have another hearing next week, but I will still register my frustration that we're having a hearing today on bills that have only been introduced for the last 17 hours. I've had absolutely no opportunity, given my schedule, to review any of this legislation, so it's a little helpful for me to be helpful to the 5 members of this committee that are on the minority side really don't have much grounding for asking questions right now. I'm just going to tell you right now, we could be asking better questions perhaps if we had had more opportunity to do that. So with that out of the way, I guess my question would be, if we were looking for an example of a state that you think is doing this well, as we kind of try to review, I understand what you're saying about the state of our laws, but who does this well? And I guess when you say we're the only ones left with criminalization, that's easy to track, but what are the outcomes we're looking for? And I guess the overall question would be, why is sort of a robust surrogacy system, why is that good for children? I understand why it'd be good for the children that are actually born into it, but is it something that, absent unusual circumstances like the ones you described for yourself, of course, is it something that we want to encourage, and why?
Yeah, this goes from conception through death. So that is why this is so comprehensive. It also includes probate law, what happens post-mortem to many of whether they're gametes, embryos. I'm going to turn it over to Polly to answer some of those additional questions. But unfortunately, there was a reason we got the final draft yesterday. We have been working on these bills for 3 years. It's nothing that has to do with the fact that these bills haven't been vetted or ready to go, just the final touches. And as you know, hunting break is coming up. But that's why we made sure to have 2 weeks.
So, thanks for unmuting me to jump into that question. And I just want to ensure the representatives that I'm happy to be available between today and next week to answer questions and to share that I think one of the goals of the bill, which is so important, is having, and that I think many states in the country are doing, is making sure that they have core family law systems that make sure that a child is protected no matter the circumstances of their birth, the marital status of their parents, that first and foremost, that legal parent-child relationship, that again is the source of every single right and responsibility for a child, is secure for every child. And so for an example, right, if you don't have, as the representative said, if you don't have a legal parent-child relationship established at birth, and your child has a medical event, you can't make decisions, your health insurance can't protect them, that is so important for children. There are a number of states who have kind of been taking another look at their parentage laws and updating them. There's the Uniform Law Commission, which is a nonpartisan commission of experts that meet nationwide, recommended that all states update their parentage laws in the Uniform Parentage Act of 2017. That's been endorsed very broadly by the American Bar Association, the National Child Support Enforcement Agency Association. In that 2017 model law, which we used in part to craft this law, and we in fact had the reporter for that Uniform Parentage Act involved in helping to craft that, essentially is saying, let's look at our parentage laws and update them to protect all children. 8 states or 7 states have already passed that updated version of the Uniform Parentage Act of 2017, most recently Colorado last year. And then a number of other states who haven't necessarily used the UPA framework, but have gone through and updated their parentage acts to protect all children, particularly those through assisted reproduction and surrogacy. For example, in New Hampshire is one of those states, for example. So I think that in this area of the law, many people see it as a very common sense kind of nuts and bolts updates that states should be doing in some of the important work to make sure children are protected, and also so that we're keeping cases out of court that don't need to be in court, right? If we can establish parentage of a child at the hospital at birth, that's really going to save resources for the state.
Okay. Polly, thank you so much. I see that Jane is up here. She hasn't spoken, and just so you know, this is the plan. Jane, I have you along with 2 other people that are testifying virtually. We are then going to switch to Senate Bill 410 and then come back to the rest of this package pending time. So please.
Thank you. Good morning, Madam Chair, members of the committee. We appreciate your time this morning. As I said, I'm attorney Jane Bassett. I practice in Ann Arbor. I've been practicing for over 30 years and have helped countless Michigan parents and children secure their legal ties when they're using assisted reproduction to form their families. Unfortunately, in order to do that, we've had to jump through a lot of hoops that other families don't have to jump through. I've worked with attorneys across the nation on these issues, and I can tell you firsthand that Michigan's laws are decades behind and do not reflect the realities of medical technology and family formation today. My clients have been faced with having to adopt their own children born to a surrogate, adopt as a step-parent when their child is born to their same-sex spouse. That's very distasteful for a parent to have to do that. Face the uncertainty of a legally unenforceable surrogacy contract over a child that they planned, conceived, and were already devoted to. Give birth in another state to ensure jurisdiction in a state with more modern laws. Remain a legal parent of someone else's child pending finalization of the adoption. Under the current laws, judges are confused and give inconsistent rulings. Some are willing to give pre-birth orders, others say it's not possible under Michigan law. The bar is confused. Clients go out and ask for legal advice from those of us who should be experts, and we can't give them a clear answer, or they get conflicting information. The result is, after spending thousands of dollars conceiving a child, of helping to grow their family, of being devoted to that child, they then have to spend thousands more in legal fees to ensure the permanency of their family relationship. This puts families under emotional and financial stress that would be avoided by the parentage laws that are before you. It also puts children at risk because things can happen between the time they're born and the time the adoption is finalized. These laws place assisted reproduction families on par with parents who are able to conceive without medical assistance. I would urge you to report this legislation, the Michigan Family Protection Act, out of committee and send it on to a full vote in the House. Thank you.
Thank you. We now have some testimony on Zoom. Nikange. Please note that we do need people testifying virtually to keep their testimony limited to 2 minutes, please.
Hi everyone. My name is Nkenge Browner. I work at Mothering Justice. We do policy work for Black and Brown mothers, and I'm a lifelong Michigan resident. The Michigan Family Protection Act is so important to me because I am a mother, but also a queer mother. Because of my identity, I knew that motherhood would be harder for me to access. With the help of a wonderful Michigan-based fertility clinic, my dream was realized. I share a son with my ex-wife, who is not a biological parent, but mother all the same. During our divorce, we realized Michigan courts struggled with understanding our family. While deciding the fate of our child's physical custody, parenting time, education, health insurance, and all of those things, my son's other parent realized her connection to her child was legally insecure based on Michigan's current standing. The children of parents conceived using fertility assistant deserve the same legal protection as other children and families. Without proper legislation, our children are at risk for losing health insurance, the financial protection of two parents, and legally upheld parenting time. This legislation is critical because Michigan law lacks clear standards to protect both parents and the child. More importantly, it leaves the children unprotected and vulnerable. We all understand the harm and trauma separating a family can do to a child. This bill will comprehensively update the state of Michigan's parentage laws, ensuring that all children have access to a clear legal relationship with their parents, regardless of the circumstances of the child's birth, the marital status, gender, or sexual orientation of the parents. Michigan has been a policy leader for bill packages like the Momnibus Act, and we urge Michigan to continue to expand protections and remain a policy pioneer for parental rights by passing the Michigan Family Protection Act. Please accept this guidance from these affected families like mine, the organizations that have been on the front line concerning these issues. Help protect our families, our children, and pass this Michigan Family Protection Act. Thank you.
Thank you very much. We're now going to turn to Katie.
Good morning. My name is Katie Christian, and I'm a lifelong Michigander, currently residing in New York as a sophomore student at Columbia University. I speak to you today in strong support of the Michigan Family Protection Act. Michigan law does not adequately protect same-sex couples raising children. When I was born through donor insemination, I was not legally the child of one of my mothers. During my first 2 years of life, my parents braved the time-consuming, financially strenuous, and invasive process of second parent adoption because parentage law claimed their verbal commitment to care for me was not enough. Upon securing the extensive credentials necessary for second parent adoption, they headed to court, and my mom with parental recognition had to terminate her rights for the process to take place. Despite having two loving mothers who wanted more than anything to care for me, I was, at that moment, a child of the adoption agency, and my mothers were no more than legal strangers to me. Only after this emotionally grueling process were they able to adopt me together? Today, Michigan still does not provide same sex couples with equal access to securing rights as parents, leaving thousands of children vulnerable. While my mothers eventually gained parental rights, many families lack the knowledge, time, or money to bear these legal obstacles. Although a young girl may grow up bragging about her two moms, by the time she reaches an age to reckon with these legal obstacles, she will feel embarrassed and become more apprehensive about who she tells. This little girl was me and exemplifies a similar story for many other children with same sex parents. Aside from depriving us of legal protections, the current laws have led too many of us falling victim to the stigmatization of our families. Yet, I assure you, the love our families share is no different from that of yours. That is why I urge you today to support the Michigan Family Protection Act, because we too deserve to be treated as families in every sense of the word.
Katie, thank you for sharing your testimony today. That was very powerful. Okay, thank you so much. Pending time, I would like to call the rest of the witnesses up, but for now, we're going to need to turn to Senate Bill 410. Thank you. And if Senator Irwin would like to hobble on up here. Hello. Tell us about your bill.
Thank you, Chair Breen. Thank you, members of the committee. Apologize for my tardiness in arriving in the middle of session, but thank you for your patience. And for hearing Senate Bill 410. As many of you already know, Michigan has a unique product liability law. There's no other state in the nation that has a law like this. It was adopted in 1995. And what it says is it says that drug makers and people who sell pharmaceutical products get blanket immunity in the state of Michigan for any drug that has been approved by the FDA. Now, I don't have that level of trust in the FDA that the legislature had back in 1995. And I don't think that our system functions well in that way. I think that accountability is maintained through a reasonable tort system. And if we pass Senate Bill 410, we will be like most other states, where there's still a rebuttable presumption that protects drug makers and sellers. It's still going to be hard for residents who are harmed or killed by drugs to get into court and to seek compensation. However, by repealing this law, we will no longer just be slamming the door in their face and telling them that they can't even have access to our courts to make their case and try to prove that they or their loved one was harmed or killed by a pharmaceutical product. I'll close by just saying that this is a big deal. I think, as many of you know, adverse drug events are a huge reason why people are hurt and why people die in this country, as pharmaceutical products have become a more and more important part of our provision of healthcare in this nation. Those statistics have only grown. And I think it makes no sense for Michigan to continue to stand out alone as a state that uniquely prohibits its residents from seeking justice when they're harmed by one of these products. Thank you, Madam Chair.
Thank you. Representative Fink, you have a question for the senator?
Yes, I do. Thank you. I appreciate, well, I guess the formality, I appreciate you being here this morning to tell us about your bill that you want passed. Of course you're here this morning. I appreciate your point, though, that there's an argument that a robust tort system is a more effective, way to police bad acting providers of service than something like the FDA. But doesn't it strike, and I know we can't repeal, we can't get rid of the FDA here, so I understand why your bill doesn't do that or try to do that. But doesn't it strike you as a little bit tricky to kind of get people coming and going? We do make the manufacturer, not us again, but as a healthcare economy in the United States, the manufacturers do have to go through this arguably overly long, overly difficult, and not terribly transparent process of getting FDA approval, and then in addition to that, to slap them with potential tort liability when there's already been this very significant gatekeeping function performed by the federal government. Doesn't that kind of getting you coming and going strike you as a little bit maybe inefficient?
It strikes me as maybe a little bit inefficient, but I think we need to be clear about what the purpose of these different systems are. The FDA process was never set up as a guarantor of the safety and efficacy of these drugs. They were never set up as a means to prevent bad actors in the pharmaceutical system. It was really set up to approve or disapprove drugs in a broad way. And I'm sure you appreciate that they're under a lot of pressure to approve these drugs, both from the pharmaceutical companies, but also from patients who are oftentimes eager for some new treatments. And using that system as the system that keeps the companies accountable when they're out there in the market operating, I just don't think it works, because they're really designed to accomplish different goals.
Yeah, but I mean, the safety and efficacy is what the FDA says that they're basing their decisions of approval on, right? I mean, so you can't sell a drug unless the FDA says it's safe. And if our tort system then says, well, even if the FDA says it's safe, you know, there's let me just instead shift to this question, and then I'll be done. You mentioned a rebuttable presumption. I assume you're talking about what I think is Section 4 of the if we delete everything starting in Section 5, Section 4 of a Products Liability Act, right? If, for instance, some of the folks who oppose this bill would like to maybe clarify that how the rebuttable presumption would work specifically with FDA-approved drugs, is that something you'd be open to?
I'm always open to any sort of ideas to make legislation better, but I would point out that rebuttable presumption remains. That Michigan is really an outlier. No other states have this, and so these arguments that there won't be innovation here, or that this will stifle that, or that drugs won't be available here as a result of this, that I think makes no sense. If that were true, then people in Michigan would have better access to drugs. We'd see more innovation here. We would see drugs being cheaper here. But no, our residents are paying for that only with their lack of access to justice.
No one else has the shield, but a rebuttable presumption, that's more common.
Yeah, I think that's very common, and I think that my legislation, which repeals the immunity, would leave that in place. If there are ways to improve it, I'm always happy to discuss it.
Thank you.
But I think it's sufficient.
Okay. Representative Fink, I would note that there are some other witnesses that might be able to more accurately or comprehensively.
You did a good job.
Okay.
Or expertly.
Okay. Just if you have, he did. I'm just saying, if you have additional questions, knowing you and how thorough you are, if you wish to get into further detail, help is on the way. So, Senator Irwin, thank you so much, and I encourage you to hobble on back to session unless you want to stay and hang out.
Thank you very much for your consideration. I really appreciate your patience.
Thank you. Oh, I'm sorry. Representative Johnson, you had a question. Was it for the senator or for one of the other witnesses?
I just want to say thank you. I'm in full support. Congratulations. I worked for a drug company for almost 20 years, and I'm not here to say it was unethical, their practices, but we cannot indemnify any group in any business where there's a monetary value and a benefit automatically built in because it's a business. We cannot take away these safeguards of having a normal legal process to report, to have accountability that way, and I hope it continues into the federal model as well. Thank you.
Thank you very much, Representative, and it gives me an opportunity to say that not everything that these manufacturers and sellers do happens as part of the FDA process as well, right? I mean, we all know about the opioid cases and the unethical things that Purdue did in selling those products and in advertising those products to doctors and patients. That all happened after the FDA process, and the only reason why Michigan had access to that opioid settlement was because of some very creative legal theories. Right? That's the only reason why we had access to that opioid settlement. And over the course of the last 20 years, Michigan has lost out on huge settlements. We lost out on the Vioxx settlement, multi-billion-dollar settlement, tens of thousands of people. We lost out on the Fen-Phen settlement, multi-billion-dollar settlement all across the country except Michigan. Right? And the state of Michigan itself lost out on settlements when the state Supreme Court said that even Medicaid couldn't try to seek compensation for the people that were harmed and the damage caused by the drugs that our taxpayers bought through Medicaid. So thank you for the additional forbearance. This is important, and I appreciate your words.
Thank you. I'm now going to call up representatives of the Attorney General's office. After that, we have Carrie Silverman, and then wrapping up drug immunity, we have Tiffany Ellis. Thank you. We have Ashley Steffen, and is it David Tanay? Tanay. Thank you, from the Attorney General's office.
Good morning. Excuse me. Thanks for the opportunity to be here. Thanks to the chair and committee members to be here, provide testimony on behalf of Attorney General Dana Nessel in support of Senate Bill 410. Again, my name is David Tanai, and I'm the Division Chief of the Attorney General's Healthcare Fraud Division. I've been with the Department of Attorney General for the last 26 years. 13 of the last years I've been in my current position as Healthcare Fraud Division Chief. One of the core duties of the Healthcare Fraud Division is to recover taxpayer dollars that have been paid out by the Medicaid program due to fraud. One way we do that is by engaging in civil actions, often in concert with other states, that are filed against large companies who cause false claims to be paid by Michigan Medicaid. Sometimes these companies are pharmaceutical manufacturers or sellers of pharmaceuticals. Of course, when we pursue a case to recover taxpayer dollars, we use the Medicaid False Claims Act. We don't file products liability actions. You may recall the drug Vioxx, manufactured by Merck, that was primarily used to treat back pain. Vioxx was FDA approved and widely used by the public all across the country. Over time, it became clear that Vioxx had dangerous cardiac side effects, and some research has indicated that up to 38,000 Americans died as a result of taking that drug. In 2008, the Michigan Attorney General and many other states brought suit against Merck for fraud. The allegation was that they should have known these side effects, but instead put a dangerous drug out in the market that Michigan Medicaid program paid for unwittingly. Merck defended our case, citing this so-called drug immunity provision, saying that Vioxx was FDA approved, therefore Michigan had no claim. We responded by pointing out to them that we did not file a products liability action, but it was a Medicaid false claims action, totally different theory, totally different statute. Nevertheless, the last and final word from the Michigan courts on this was that that difference ultimately didn't matter. In 2011, the courts concluded that the claims were similar enough to invoke the immunity provision, barring those claims against Merck. Since then, it has been clear that similar claims against drug manufacturers based on Medicaid fraud or products liability could not be maintained in Michigan by anyone. More recently, this immunity provision factored into the ability of the AG to straightforwardly pursue claims for conduct of certain companies in the context of the opioid epidemic. While the Attorney General was ultimately successful in litigating claims against a host of opioid defendants, the existence of this unique provision greatly complicated that approach. The special protection afforded to manufacturers and sellers of drugs that are discovered to be dangerous or ineffective fails to best serve Michiganders, and it should be stricken, in our view, from the statute, which is precisely what Senate Bill 410 does. By ending this immunity, Michigan will be placed in a similar position as the rest of the country. Thank you. Are there any questions for me?
Nope, seeing none. Ms. Steffen, do you have anything to add? Or
He covered it.
okay, please make sure you fill out a card. Okay. Now I'd like to turn to Carrie Silverman on Zoom.
Good morning, Madam Chair and members of the committee. Thank you for the opportunity to testify today. My name is Carrie Silverman, and I'm here as counsel to the American Tort Reform Association, which is a national organization that supports a balanced and fair civil justice system. ATRA respectfully opposes SB 410 in its current form. As introduced, as you know, this bill will fully repeal a portion of Michigan's Product Liability Act that's been in place for over 25 years. And the purpose of that section is to make sure that the expertise of the federal agency that's charged with ensuring drug safety is reflected when courts are deciding lawsuits challenging whether a medication was unreasonably dangerous or a warning label was inadequate. Medications have great benefits, but they all carry some level of risk, unfortunately. The responsibility of the FDA is to evaluate those risks based on science. The agency approves applications for new medications after years of testing and patient trials, only after finding that a medication provides benefits that outweigh its known and its potential risks. Even after a drug is approved, the FDA continues to receive adverse event reports from healthcare professionals and patients, safety reports from the manufacturer, results of new studies, requests to add or change labels to reflect new risks. And it can require new warnings, and it does, and it can recall and withdraw its approval or, when safety and science require it do so. Lawsuits that assert that a medication is unsafe, even when the FDA found it beneficial, or claim that warnings are inadequate, even when the FDA specifically mandated those very warnings, are in conflict or at least considerable tension with the FDA. The purpose of the Michigan's law that we're talking about today is to align liability with the FDA's decision making. And ATRA agrees with the principles that are behind this section. The alternative is to decide what are very complex scientific issues on a case-by-case basis in the context of individual lawsuits with hired gun experts on both sides. And the current statute sometimes is presented as it was today, as providing a blanket defense or complete immunity to drug makers. That's not what the statute says, nor I think was that the intent. As it's written, the statute says that a manufacturer is supposed to remain subject to liability if a medication is sold after the FDA withdraws or recalls a product, if the manufacturer intentionally withheld or misrepresented material information from the FDA, or if the approval was gotten by illegal means. In other words, if a company did what it was supposed to do and the process worked as it should, an FDA-approved drug wouldn't be found unsafe or defective. Now, I understand that after the statute was enacted, courts ruled that what is known as the fraud on the FDA exception, or withholding information or misrepresenting information exception, can only apply after the FDA itself has found that the manufacturer failed to fulfill its obligations. So if the committee feels that the current exceptions as written or as they've been applied by courts are now too narrow for plaintiffs to meet, which wasn't the intent, I don't believe, ATRA would suggest that it consider alternatives to repealing this provision completely that will provide new paths for those who believe they've been injured by a drug to seek recovery. And that might take the form of a rebuttable presumption that is specific to FDA-approved drugs. As you know, Michigan, it was mentioned earlier, Michigan already has a rebuttable presumption for other products. Several other states do as well. Montana enacted one this year. But we think with respect to a presumption for FDA-approved medications that go through a particularly long, rigorous, and expensive process, it should be tailored to that type of process. And ATRA would be pleased to work with the committee on developing an approach, a balanced approach along these lines that reflects both sound health policy and product liability law. Thank you again for the opportunity to testify remotely, and I would welcome any questions you have.
Thank you. We have one question from Representative Outman, and then I neglected to say we have Mr. Greenspan on Zoom, and then Ms. Ellis. So, Representative Outman.
Thank you, Madam Chair, and thank you, sir, for being here to testify. I just have a general question about perception of the FDA, I guess. I would like to ask you, how do you expect members of the public to trust the FDA when I continue to see a revolving door of FDA members joining pharmaceutical executive boards after their time on the FDA? It just seems like a very unethical process. Can you respond to that?
I'm not an FDA lawyer, and I can't tell you exactly. I think that the agency, I would rather put my trust, in our FDA than the hired gun experts that are hired by both sides in litigation and fight it out over sometimes generated so-called scientific studies. I place a lot more faith in the experts.
Sir, if I could just interject, do you think it's unethical for members of the FDA to then go on to join a board of a pharmaceutical company? I mean, doesn't that breed distrust in the entire FDA agency?
It's not an area that it's not an area that I have any background to comment on.
Okay, well, I'll yield back to the chair. But again, thank you for being here to testify.
It's an interesting question there, Representative Outman. Thank you. Thank you for your testimony, and we will have some continued discussions, I believe, over the next week. I'd like now to turn to Mr. Henry Greenspan. And, sir, if you could please limit your testimony to no more than 3 minutes.
Okay, thank you. I'm here as a private citizen I have testified now, this is the 5th time on this issue since 2006. I have that much experience. I'm not a lawyer, I'm not a plaintiff, but I did teach about FDA, pharma, and ethics for some years at the University of Michigan, that place down the road. Here's what I want to focus on. I provided written testimony. After all of these years, I think I was able to boil down the issues pretty succinctly. I do hope you'll take a look at that. So here I'm going to zero in on one. First, I want to go back to this question of the relationship between FDA and tort liability quickly and quote the FDA itself on this question. This is from FDA Chief Counsel Margaret Porter, who said, quote, FDA's view is that product approval and state tort liability usually operate independently, each providing a significant yet distinct layer of consumer protection. So effectively, what our Michigan law did was lop off one of those layers of consumer protection. Now, one of the ways that that shows itself clearly is that there are a lot of issues that come up in other states, in other questions of liability, which have nothing to do directly with FDA approval. As important as that is, I love FDA, to tell you the truth. I'm a big fan of FDA. Yes, it has its problems. Who doesn't and what doesn't? But the point is that there are all kinds of delinquencies that can happen. Some were mentioned in the case of the opioid litigation, which are not about FDA approval or not approval. They concern, for example, illicit marketing for drugs, usually done in secret effectively, for off-label, for uses and at doses never approved by FDA. Companies do get busted for that at times, but it's not about FDA approval. There are cases, not uncommon, in which FDA falsely informs docs, prescribers, as well as patients in direct-to-consumer marketing. And in other states, they can be held, those companies, liable for that. Here's the most important thing when we're talking about FDA. A company will always know more and know sooner about their drug, obviously because it's their drug, because they developed it, always than FDA. And so when red flags come up in the course of either during or after approval, it becomes a question of what will the company do in response to the signals they're getting? There may be problems, there may be red flags. Will they pursue them? Will they appropriately do adequate studies to discern, are these serious or not serious? Or will they avoid? Will they camouflage? Will they take their time? And in the meantime, in some of the more egregious cases, that avoidance can go on for years. In the case of Vioxx, for example, which is extreme in its way, somewhere between 30,000 and 70,000 people died of cardiac issues that probably would not have died during that period, we call excess deaths, the context of these issues, had Merck in this case, but it could be any company, I actually like Merck as a company, done their diligence early on. Now, this has nothing again to do with FDA. Part of what they avoided was doing the studies.
Sir, I'm going to have to ask you to wrap it up. I'm so sorry.
Okay. All right.
There might be an opportunity for you to speak next week as well.
No, I respect that. It's so this is the final point. Once again, these kinds of issues, which are probably the most serious ones when a company, is the old Watergate thing. What did they know? When did they know it? And what did they do? When a company is found to know but not act, this is where people really get hurt. This is entirely outside the issue of FDA approval per se, and which our law ignores as a relevant scenario. And this is why, as Mark Porter said, FDA Chief Counsel, the two systems operate in a complementary way. Thank you.
Thank you very much, sir. I'd like to call up Tiffany Ellis while she makes her way. I'm going to read in some cars. Opposing the bill, not wishing to speak, Carlos Gutierrez of the Consumer Health Protection Association. Opposing the bill, Peter Fotis of the Pharmaceutical Research and Manufacturer Association. Opposing the bill as written, Wendy Block from the Michigan Chamber, and I thank her for her conversation this morning about this. Supporting the bill, not wishing to speak, Linda Davis of Families Against Narcotics. Supporting the bill not wishing to speak, Gabe Bassa from Blue Cross Blue Shield of Michigan. Supporting the bill not wishing to speak, Todd Tennis, representing the negligence law section of the State Bar of Michigan. And supporting the bill not wishing to speak, Adam Carlson for the Michigan Health and Hospital Association, as well as the Michigan Manufacturers Association, opposing the bill as introduced, and Mr. Greenspan, who just testified, supporting the bill. Thank you. Ms. Ellis.
Thank you, Chairwoman Green.
And before you get started, I know that we did have some discussion. First of all, you're going to want to press your red button, but also there's been some discussion about the rebuttable presumption. I have spoken with you about the proposed amendments and changes from the Michigan Chamber, and I would really like to hear your thoughts on that in addition to the testimony that you have today. Please keep it as short as you can. Thank you.
Thank you. I'll introduce myself first, and then I want to talk about the real world implications of this, and then I'll turn to the legalese, just as a broad overview of what I will be talking about. My name is Tiffany Ellis. I am an attorney, and I've spent my career as an attorney representing victims and consumers. I grew up in a small town in the Thumb, and this is what I've done the entire time I've been back in Michigan. My firm, Whites & Luxembourg, is a national leader in the representation of people who have been injured or killed by defective drugs and devices. I personally, in the last 5 years, have spent my time in the opioid litigation, representing over 62 Michigan cities and counties in their claims against the manufacturers, distributors, and sellers of opioid products, including as part of the trial team in San Francisco that had led to the recovery of hundreds of millions of dollars in funds to abate that crisis. Michigan actually is over $1 billion in recovery to date in abatement funds because of the opioid epidemic. I'll note at the outset, the only reason why we were able to recover those funds in spite of this law is because our claims were based in public nuisance and not necessarily the safety of the drug or the FDA's warning. I speak today in support of 410 on behalf of the Michigan Association for Justice. When this law was passed in 1995, shielding drug companies, we were misled. And unfortunately, we've been continued to be misled. Drugs have not gotten safer, they've not gotten cheaper, and jobs have not come to our state from the pharmaceutical manufacturing industry. It simply has not happened. Representative Fink, I appreciate your questions about the Food and Drug Administration, and I do appreciate that there is a long process, an expensive one, as we just heard from one of the other individuals testifying. That being said, despite that process, it is not entirely transparent. I think if it were, we'd know a little bit more about the funding of the studies that go into the approval of these drugs, the funding of the operations of the agency itself, and the impact of how that plays out in the marketplace when it comes to those drugs. And despite those long, lengthy, expensive, and I think what was the word that you used, burdensome process, the bad drugs still get through. Here are just a few examples. Julia Garcia was prescribed the drug Duract to treat neck pain, and she suffered liver failure. It required a liver transplant. The New Jersey pharma company Wyeth was off the hook thanks to Michigan's law, while Miss Garcia was left without recourse. Notably, this drug was withdrawn from the market because of liver toxicity. Risperdal, an antipsychotic, causes young boys and men to grow breasts. Numerous cases went to trial and consolidated litigation against Pennsylvania defendant Smith Kline and then settled for hundreds of millions of dollars. All of Michigan's plaintiffs, all of those young men who had grown breasts were thrown out of court due to the drug immunity law. Notably, our state Medicaid agencies that had to pay for mastectomies for those young men could not recoup the funds that they had paid out of, that we as taxpayers paid for that care. Vicki Marsh was prescribed the psoriasis medication Raptiva made by Delaware company Genentech. That was later pulled from the market due to its propensity to induce infections. She developed viral meningitis and then a collapsed lung, among other injuries. She and 3 other Michiganders with grave adverse events, one of who died, were all thrown out of court due to the Michigan Liability Shield. And you may have heard about a settlement just earlier this month by the drug company AstraZeneca, a Delaware company. It said that it would pay $425 million to settle about 11,000 lawsuits of people who had developed chronic kidney disease after using PPIs. You may have heard of Nexium and Prilosec. That's what we're talking about, heartburn drugs. Sadly, our Michiganders cannot participate and will not receive any of those funds because of this law. Marfirm alone had approximately 500 people from Michigan who could not recover for their injuries. The results of this law are real. They have an impact on our people, and they have an impact on our state's budget. Now, Representative Breen, thank you for your questions about the exceptions. I would like to now turn to the law itself. Purportedly, there is an exception to this law. In theory, if a manufacturer intentionally withholds or misrepresents material information about the drug that was required to be submitted under the Food and Drugs Cosmetic Act, and the drug would not be approved, then there's an exception. Unfortunately, what happened is 6 years after this law was passed, the U.S. Supreme Court said that only the FDA can assert this defense. That decision has been held up time and time again by federal courts around the country. It doesn't matter what the legislature intended. It doesn't matter what the words say. The reality is this is a complete and total bar by residents of the state of Michigan for drugs that have been approved by the FDA when they are injured and killed. There's no justice for those folks. The question about a rebuttable presumption is also an interesting one. I'll direct you to Section 4 of the existing statute. The very first sentence of that section says, in a product liability action brought by a manufacturer or seller for harm allegedly caused by a product, there is a rebuttable presumption that the manufacturer or seller is not liable if, at the time the specific unit was sold or delivered to the purchaser or user, that aspect of the product was in compliance with the law. That doesn't mean just drugs. That means any product that's in the market in Michigan. So any suggestion that we need a specific rebuttable presumption is a misnomer. It's a guise. It's a wolf in sheep's clothing, quite frankly. And I was handed some language this morning that I'm not sure if the committee has seen or not, but I would like to discuss some parts of it. First off, not only does the rebuttable presumption already exist, Section 4 goes further. It actually puts the legislature, and the legislature did put itself on the bench when it wrote this law. It talks about what is relevant in a lawsuit, and it talks about what is admissible in a lawsuit. Other states do not go that far. It also does not account for federal laws about preemption that we all still must deal with when we litigate these cases. If Section 5 is repealed, it does not mean there's going to be an onslaught of lawsuits. It does not mean that these lawsuits are going to be won. It simply means that people will get to the courthouse steps. In fact, when we talk about the role of the FDA, our Supreme Court has said in the Wyeth decision, and I will submit written testimony after this with cites to all of this, and I'm happy to have longer conversations with any of you about that. But the Supreme Court has said, and I'd encourage you to read it, that Congress was reluctant to displace state laws that penalize drug manufacturers, and the insistence that by Congress that drug manufacturers are the ones that should bear the responsibility for the content of their warnings. So Congress has already made a decision that state laws should preside or should prevail over the FDA. If Congress thought that the FDA's decisions should have been airtight and should have been a complete bar, they had the power to enact immunity. Congress did not do that. Michigan did. Now, in addition to the rebuttable presumption that is already in the law and is completely unnecessary, the language that I saw this morning has a number of other problematic features that have wide-ranging implications that are a slippery slope for our civil justice system. A Seventh Amendment right, I might remind you, that is protected under our U.S. Constitution. First, if and when you look at this language, and I encourage you to do so with a close eye, not only does it say that there's a rebuttable presumption, but it changes the burden of proof by which civil plaintiffs have to prove their case. In a civil case, it's a preponderance of the evidence. What that means is simply that it's a little bit more likely than not that something is true. This proposed language that the Chamber has put forth tries to heighten this to a clear and convincing standard. Now, that's not beyond a reasonable doubt, but sure as heck is closer to a beyond a reasonable doubt than a preponderance of the evidence. It goes further to say that the defendant knew with substantial scientific certainty. Now, Representative Fink, I think that you mentioned this as well, or perhaps it was our colleague from the Tort Reform Association. Substantial scientific certainty is not really something that we can legislate. It's something that courts decide every single day when we look at the reliability of experts in Daubert hearings. It's also something that we know goes incredibly wrong, and we know that because of the opioid epidemic that we find ourselves in. When the Sackler family in Purdue wanted to sell OxyContin based on one of the most addictive substances in the history of the world, like Tic Tacs, they found scientists and they found doctors that would create the science for them that they could go and sell to convince people to take this drug for things like headaches and chronic pain when it should have been and was approved mostly for end of life and hospice care. So the language about substantial scientific certainty is problematic. Moreover, if you go to Section B, it goes on to say in this proposed language by the chamber what a court shall dismiss. I'm happy to discuss this.
Yes,
at length,
Ms.
but-
Ellis, I'm sorry. We are actually out of time. So I want to thank everybody for their patience. Representative Fink, do you want to ask a quick question before we stop?
Yeah, I do. I just want to clarify that I don't think any of us have in front of us the same language you do, so it's difficult to follow along. I mean, we can talk more during the week if it's necessary. You mentioned, for instance, that the opioid cases have been proceeding as public nuisance cases. If I remember right, Wyeth against Levine was a failure to warn case, not a products liability case. So I guess my question is, are any of the cases you mentioned, have they still been proceeding under other theories like this drug given to men and boys who grew breasts or any of these other things? I mean, was there still a failure to warn case for those people, or were they completely out of litigation?
I can't speak to the specifics of each of them right now. I'm happy to follow up with you on those.
If you could give me the citations and how those cases went, that would be helpful.
Those citations will be in the written testimony that I submit.
Thank you.
Representative Ream, if I can just say one quick point to wrap up. I'm happy to also discuss where this would put Michigan law, both in terms of repeal in comparison to other states. If we repeal Section 5, it still leaves us with one of the strictest laws in the entire country. If we were to adopt the proposed amendments that I saw this morning, it would make law even more strict than it is today in many ways. At the end of the day, this comes down to whether you're going to stand on the side of the needy for people who have been injured or killed, or the side of the greedy and companies that want to protect their bottom line. Thank you.
Thank you. I look forward to everybody continuing some of these discussions offline. I welcome you back next week to conclude any testimony, and to the Michigan Fertility Alliance, thank them for their testimony. It is very emotionally fraught. I understand this. We have members that were up here that are going to face their own difficulties. My darling nephew Carter himself was conceived via IVF. So this is a very tough topic, both of these actually, and I look forward to continued testimony and discussions next week. Thank you. Oh, before we leave, I have some additional cards. Genevieve Marnin, Right to Life, opposing the bills as written, noting that she will have an opportunity to speak next week. For this is the bills 5207 to 5215. 5207 to 5215, also opposing the bills, looking forward to testifying next week. Rebecca Mastey from the Michigan Catholic Conference. Naomi Goldberg from the Michigan Fraternity Alliance, supporting the bills, not wishing to speak. Jeanne Browell from the Michigan Fertility Alliance, 5207 to 5215, supporting the bills, not wishing to speak. Opposing the bills, not wishing to speak, 5207 to 5215, Advocates for Better Care, Hennessy Bivens. Audrey Gochi from the Michigan Fertility Alliance, wishing to speak. She will have an opportunity next week. Alexandra Kramer, also from the Michigan Fertility Alliance, supporting the bills, wishing to speak, and with an opportunity next week. Rachel Lang, also from the Michigan Fertility Alliance, wishing to speak. She will have an opportunity next week. And finally, we have Equality Michigan for House Bills 5207 to 5215, not wishing to speak, supporting, and the ACLU of Michigan also supporting 5207 to 5215. And they will be submitting written testimony. Thank you. Seeing no further business before the committee, we are adjourned.